Still in the matter of Riley and another, a National Westminster Bank PLC.
Yes, Mr. Sim.
Good morning, my lords. My lords, I appear with Mr. Amell for the appellants, and my learned friend Mr. Sinclair of King's Counsel appears with Mr. Brock for the respondent. My lords, hopefully the bundles are all in good order. You should have a core bundle and a supplementary bundle, and then also an authorities bundle.
Four, indeed.
Four,
Yes.
indeed. Some of them, perhaps we might have been more selective as regards the parts that we included in the hard copy, so apologies if it's a bit overly cumbersome for that reason. In relation to the question of the order of the batting order, so to speak, subject to the court's contrary views, the appeal and the response notice has been listed to be heard over 2 days.
Yes.
And I've agreed a provisional timetable with my learned friend as follows. I'm to open our appeal this morning, and clearly, obviously, I'll be concentrating on the settlement issues in relation to our appeal. The bank will then respond this afternoon on that appeal. Subject to your lordship's view, it would be proposed that my learned friend would then continue to the extent he has further continuance in response tomorrow morning, and also then opens his respondent's notice points on limitation. And then I respond tomorrow afternoon on limitation and a reply on settlement at the same time, with my learned friend then to have a brief reply on limitation at the end.
Yes. Yes.
So that's what we provisionally agreed between us, because we thought probably it made sense from a point of view of efficiency. But it's obviously if your lordships want to.
Yes, that was our view too. We don't necessarily have to take the whole 2 days. We'll see how we go. But I think we do think that Mr. Sinclair should, as it were, open limitation rather than you're trying to deal with it at the start.
Good. Well, my lords, obviously if we make better progress than that, then we'll seek to try and bank it, so to speak, and not expand elsewhere. In relation to the structure of our appeal and the opening of our appeal, just to give your lordships a sort of heads up, so to speak, as regards what I intend to cover and the order in which I intend to cover it. I propose to start with a summary of the points or propositions which we seek to make on our appeal by reference to our grounds, and also certain case law picked out in relation to the key headlines, so to speak. And then propose to do some scene setting and a brief review of the relevant personnel, documents and facts, before then coming back to our submissions on the grounds and seeking to amplify each of those and taking them in the order in which we set them out in our written argument. So dealing with ground 5 first, which has been referred to as the RHL point, and then dealing with grounds 1 and 2 to do with the sharp practice principle together, followed by ground 3 to do with the question of construction. To a certain extent, the case law and the submissions in relation to all those 3 areas has some overlap. And then ground 4 last, which is obviously to do with the question of inducement stroke reliance, and the issues arising in that respect are somewhat distinct and separate. I propose to deal with those last.
My only comment on that is that, sure, as a matter of logic, you can only engage with sharp practice once you've worked out what the contract means.
Yes, I think the way we would put our submissions in that respect is to assume against ourselves. You're against us on our construction.
Why would you do that?
Well, I'll give some thought as to whether or not I can restructure them on the top of my head. I think actually the case law which I'm intending to go to looks at the principles from both perspectives, but I can look at whether I can take it out of order or not. But the reason why we thought it may be of assistance to deal with it in that way is it may guard against the conclusion simply because your lordships have concluded, or the judge at first instance has concluded in one way on the construction issue. It necessarily follows that disposes of the sharp practice principle. and we think there's a risk that if you take it in the other order, the logically distinct questions arising on sharp practice may not be given the attention they deserve. But I'll to the extent I can.
Or do you hope that your arguments on sharp practice colour the arguments on interpretation?
I'm not sure if that certainly wasn't didn't sort of go through my mind in that way. Clearly, they're closely related in terms of the issues, and obviously we recognise the points that the sharp practice principle is set in the context of an objective consideration of the contract and what the parties intended. Layered on top of that, of course, is the question of the subjective question which arises in the sharp practice principle cases, and unconscionability, which is obviously very much directed at the releasee's conscience and their state of mind and conduct, which arises independently of the questions of construction, subject to obviously argument about precisely what the principle is, which of course is...
Well, is it independent? I mean, it must be dependent upon what the parties have agreed in the first instance, mustn't it?
It's independent in the sense that it's not concluded by the agreement.
No, but the scope for it must be dependent upon construction. In fact, that's what I said in Maranello.
I don't disagree with the notion that the sharp practice principle must necessarily be viewed through the prism of what the parties have agreed. I don't demur from that proposition. But we think it's important, even in a case where the court may have concluded, as the judge did in the court below, that the scope of the document as a matter of construction is sufficiently wide to capture the claim in question which has allegedly been released. Nevertheless, the principle still has a role to play. So that's making the point against ourselves on construction, taking it on the chin, so to speak, right at the outset. But I recognise the fact that logically you could take them the other way.
You're also taking ground 5 first.
Yes.
Which is a construction.
Yes, the reason why we're taking ground 5 first is it seemed to us it was logically a very different point in relation to...
It's all a matter of construing the same clause.
Yes, it's considering the same contract, but gives rise to a very different set of issues.
It does, Mr. Sims. I'm sure we wouldn't want to impose on you if you've been spending the last hours or days or weeks thinking along a particular line. But speaking for myself, it does seem a bit odd that the most important document in all these documents is the settlement deed, especially clause 7.1. So doesn't one start by looking at it and saying what does it mean? And so doesn't ground 3 logically come first before you get on to anything else, particularly ground 5?
Well, I'm not sure if I'd necessarily put it in quite the way. In a sense, I can see that conceptually ground 3 and ground 5 could be said to form part of the same process, which is the question of construction. So I recognise that. I think in the section on the scene setting and looking at the key facts and documents, we do propose to use that exercise to take your lordships to the documents and identify the key context to the agreement and the facts and the parts of the agreement which we say are pertinent to points more generally. So I hope in that way, conceptually, we'll give your lordship the points that your lordship may be looking for from me in relation to that. I think then the legal points which arise in relation to ground 5 are quite different in concept. So I'll give consideration to whether on my feet I can do some rejigging, but that's the course we propose to take, and I fully recognise and obviously have on board the observations you've made about conceptually how you may prefer to deal with it, and to the extent that there are logically anterior points that need to be addressed as part of those arguments, and obviously I'll give some thought to that as we go along. So, my lords, in relation to the summary of the points we would make in relation to the reasons why the appeal should be allowed, Firstly, in relation to ground 5, and this point obviously, to the extent it deals with questions of construction, overlaps with ground 3, but particularly in relation to ground 5, we would submit general words of release are controlled by context and have no greater reach than the context requires or indicates. And the task at hand in relation to the settlement concerned the personal liabilities of the Rileys to the bank, and the target in relation to the release was concerning the claims between the Rileys and the bank, not claims held by a third party, RHL, which was not a party to the agreement, and at the time in question was under the conduct and control of the administrators. It did not expressly or indeed tangentially even remotely consider the question of the acquisition by the Rileys of from RHL after the event. Assignments were not discussed or mentioned in any of the documents which precedes the settlement deed and aren't mentioned in the settlement deed. So we submit that that context should have resulted in the judge concluding the release did not apply to RHL claims or assigned claims from RHL to the Rileys.
Is this right? You stress that when you're going to we look at it, you're going to stress that it's dealing with the personal liabilities qua guarantors.
Qua guarantors
of the Rileys.
and qua their own personal facilities.
Yeah.
And our primary and first complaint in relation to the judge's reasoning in relation to this at paragraph 110 of the judgment is that he appears to have taken the approach, well, the plain wording is sufficiently wide to capture an assigned claim, therefore your argument, Mr. Sims, fails. And in doing so, with respect, we would submit that that fails to take into account the principle as laid down by the House of Lords in BCCI that this is a contextual interpretation process. See paragraph 29 in particular. We would also submit that it is very odd indeed to conclude that a cause of action in Mr. Riley's hand, which obviously could not take place until an assignment deed had been executed after the event, would have been contemplated as falling conceptually within the category of claims under consideration as part of the deed. And we refer to a passage on that in the Court of Appeal in BCCI by the Vice-Chancellor in paragraph 7. I'll come back to all these points in the case in due course. We also say that the contextual analysis which the court should have adopted was very similar to that which was analysed in Kazmini and Siddiqui, which is the only case we've been able to identify which examines the question of whether or not an assignment would be called by a release deed in circumstances which have parallels to this case. And in particular, we would invite your lordships to note paragraphs 11 and 14 to 15 of the judgment of Lord Justice Moore-Bick in Kazmini.
So we're coming back to that bit.
We're coming back to all these things, yes. That's strand 1, if you like, of ground 5. Strand 2 is the position is even stronger when one appreciates that the claim as assigned is held by Mr. Riley on trust on the same terms as was held by the company administration. The judge refers to the fact that it may also have gone briefly into liquidation. I don't think for present purposes that analysis matters. But
why? Sorry, I've missed this point. Why do you say that the claim he took? So you're saying that the claim is held by Mr. Riley as trustee for some purpose.
In effect, Mr. Riley took the assignment from the Duchy of Lancaster.
Right.
on the basis that he would apply the proceeds on the same statutory scheme as the insolvency. So as if it were an RHL claim being applied in accordance with the statutory trusts, which obviously come into existence on administration or liquidation. And we'll take you to the particular passage in the assignment document which provides for that.
Okay.
At the time, at the time all this was going on, or before 2014, were the shareholders of RHL Mr. and Mrs. Riley?
Mr. Riley was the sole shareholder in RHL.
So that the assignment from the Duchy of Lancaster could then have been to anyone.
Could have been.
Why was it to Mr. Riley then?
My understanding is that the Duchy of Lancaster had a preference for it being provided to Mr. Riley because he was the 100% shareholder. That's the extent I know. So it may well be that they viewed this as not dissimilar to the situation where you have a restoration of a company and imposing on Mr. Riley the same obligations as if this were a restoration with, in effect, him prosecuting the claim on behalf of RHL. In other words, he would only get any surplus after the payment of the creditors.
It's slightly weird because normally what would happen is in the modern era, the claims are normally sold by the office holder for cash because then they can make a distribution of the cash and the claim can then be pursued by the assignee in his or her own interests, and they keep the money, and that's the normal way these days, because it enables a liquidator or an administrator to bring the insolvency proceeding to a more efficient and swift end by realising a sum of money certain. This mechanism, which I've now got up in front of me, and I hadn't really spotted clause 2.
Yes.
It's slightly unusual because it, in a sense, will require, presumably, Mr. Riley as assignee to conduct a sort of out-of-court distribution as liquidator would have done, without the assistance of the liquidator, who presumably has the records of the company and its creditors.
He will, to the extent there are any issues arising out of that, obviously need to seek directions from the court. But
as trustee,
as trustee, yes, of this cause.
of these funds. Yeah.
I recognise that if the administrators had recognised this as an asset before dissolution, that would be the conventional course.
Yeah, but it's funny. I haven't done restorations of companies for quite a long time, but in the dim and distant past, normally the Duchy used to insist on a restoration, especially where the company had gone into an insolvency process for this very reason.
They didn't in this case.
Okay,
is the short answer. So.
Fine.
But I think that what they do seem to have done is insisted on an assignment to Mr. Riley as the 100% shareholder and clause 2.
And do we know what the state of the insolvency of the company was, i.e. do we know what its creditors are unpaid?
We have the statutory information.
Yes. There are unpaid creditors.
Yes, still. Yes. The bank had a shortfall and there were unsecured creditors, trade creditors. The Rileys were creditors. So there were other creditors.
So the bank is the secured creditor.
The bank is a secured creditor.
So the bank's any recoveries will first go to pay the secured creditor.
Exactly. So the way we pleaded our losses is for the difference between the position the company would have been in, but for the administration, which we project at a figure of 70 million or thereabouts. And clearly, if the net deficiency is made up of a certain sum which needs to be paid to the bank, then the difference is our claim. Ultimately, it washes out as part of the process because it will get netted off in that respect. But clearly, our claim would need to be saved for a sum which was in excess of the sum owed to the bank.
Right. But what you're stressing is that you're focusing on the fact that this is a cause of action which was an asset of the company at the time of the settlement agreement, which was under the control of the either administrators or liquidators. I don't know which.
Administrators at this time.
I mean, we don't know when the company went into liquidation, I don't think.
No,
I don't know. There is a hint in the judgment in one of the early paragraphs that the administrators were appointed by the bank.
Yes.
And presumably, and did the administrators become liquidators? It would be useful to know.
Yeah, so the administrators were in office until 2015, shortly before dissolution. The judge seems to have thought that there may have been a brief liquidation before dissolution striking off. But
yes, but let's put it this way, he would have been forgiven for thinking that, given the terms on which this assignment talks about the company was wound up by its former liquidators.
Yes.
My Lord's already found the assignment. Can you tell us where it is?
Yes, it's
it's tab 12.
Tab 12, so tab 11 is the settlement deed. And then tab 12 is the deed of assignment, and it's at page 302. And you see reference to Mr. Riley as the assignee in the title. And you can also see reference to him in his capacity as former shareholder within the definition of the party, the second party. And then you can see reference to dissolution. And the registered office at the Zenith building at the time of dissolution was the offices of the insolvency practitioners in Manchester. And yes, it's clause 2, which is key for present purposes on page 304 in the deed. So your Lordship is quite right that we don't criticise the judge for concluding there may have been a brief CVL or liquidation after the administration. I don't think for present purpose it matters. It's common ground the administrators were in place between 2012 and 2015.
I mean, it is quite. I mean, the whole deed is a very odd deed. I think it's been not very well adapted from a model by the look of it.
But we're not seeking to argue that it does anything other than similar to a restoration would do in the context of
well, what you're doing is highlighting, I think, as context to the interpretation of the settlement deed in relation to clause 5, that there was an extant cause of action in the company.
Exactly.
Which was at the time in different hands from the Rileys.
Exactly.
And you will come on to, I think, argue that if it had been intended to objectively to settle that claim, release that claim, a different wording or at least different technique might have been adopted when you come to the clause 7.
Exactly. And this is a business-like document, settlement deed, drafted by the solicitors for the bank at a time when everyone knew the administrators were in place. And it would be most unbusinesslike of them to have...
Well, they could have asked the administrators to join the settlement.
Exactly. There are all sorts of reasons why the objective indicators are that no one actually addressed their mind to the issue of this being assigned or had it in contemplation.
Suppose that the day after the settlement was signed, Mr. Riley had approached the administrators and asked to ask for an assignment of the company's cause of action, and that had been agreed to. You're saying that the next day, Mr. Riley personally could have sued the bank.
Could have done,
yeah.
Yes. But contextually, one has to ask oneself, if Mr. Riley had done that the next day, the administrators would have turned around and said, well, hang on a second, what is the claim? Why haven't you identified this before as an asset which you think that the company has? There were all sorts of questions that would have been asked about the duties and responsibilities of those directors, thinking there was a valuable cause of action in the company's hands. And moreover, if the administrators thought it had any substantial worth, they would have required a price to be paid for it or some sort of consideration.
Well, this is why it would be useful to know, for example, who appointed the administrators, because the administrators, to pick up my Lord's point, the administrators have a duty to all creditors, including the secured creditors, to realise the assets of the company.
Yes, I'm pretty sure that it was a bank appointment.
That's what's suggested, I think, by paragraph 6 or 7 of the judgment.
Yes, I don't think there's any issue that
but
it was
it
the
would
bank.
be useful to know. But
yes,
I mean, we're going to come on to all these points. I'm not sure why, in a sense, you outlined these, because we might as well just get on with them. But presumably, it would have been perfectly possible for the bank to have contacted its appointees.
absolutely.
And admittedly, they have duties to all creditors, but if they're appointed by the bank, you assume there's a relatively good line of communication.
They were in contact with them. We can see that from the documents.
Yeah, and they could have joined the RHL into the release.
Absolutely. They had it within their power. If they perceived there was a valuable claim by RHL and there was a risk that to pose the scenario by my Lord Justice Dean, that an assignment could have taken place the next day in some sort of clever side step by the Rileys, they had the ability to...
Well, you just say the objective bystander, if asked to interpret this, would have, if asked the day after, is there a claim still extant from RHL, would have said, well, yes, because the administrators haven't even been made parties to this, so what has it got to do with
exactly
releasing the claim? In fact, the administrators of RHL could themselves the next day have decided.
Absolutely.
I mean, do we have any of the... is there any material to show either who they were, or is there one of their reports to creditors?
There was
which would presumably be part of the background available to all parties.
Yes, the reports are publicly available in relation to the administration.
Yeah. Do we have them?
Some were referred to by Mrs. Riley. I'm not sure if all of them were referred to, but the contextual scenario was absolutely clear that the administrators hadn't identified any claim. There was no hint or suggestion that the administrators thought they had a claim. The Rileys didn't think they had the claim they're now pursuing. The administrators dissolved the company or caused it to go into liquidation and then subsequent dissolution because there were no further assets identified by the administrator. That's why it goes into dissolution. If they thought that there was an asset of any value, then they would have carried out the usual process that my Lord has identified of seeking to realise value for the benefit of the company and its creditors.
Can I ask, as we looked at the assignment, why do you say that Mr. Riley holds the proceeds on trust?
Because he agreed that the claim and any proceeds from the claim would be applied in accordance with the prior liquidation of the company, in particular concerning settlement of creditors.
That doesn't create a trust, does it?
What, in my submission, it does, because he's not free to dispose of that money at his will. It's imposed. There's no sort of free ability for him to deal with the assets.
Well, it doesn't use any words which would be apt to create a trust.
But in substance, it's clearly a quis-close trust, isn't it? It's transferred to him for a purpose.
Oh, it can't be quis-close, surely.
Or,
I mean, but in any event, pick up my Lord's point. At the end of what meaning do you give to the word at the end of clause 1 to hold the same unto the assignee absolutely? I mean, I think my Lord's point to you is clause 1 seems to be an absolute assignment without any words of trust, and the second clause is a contractual arrangement between the assignee and the Duchy of Lancaster to apply the funds in accordance with certain terms. But is that automatically a trust, or is it simply a contractual obligation which is enforceable by the Duchy of Lancaster?
Well, the way we've previously interpreted these two clauses is it's an absolute assignment in the sense that the Duchy of Lancaster holds no residue to it, but it's transferred on the basis that we agreeing that any funds recovery will be applied in
Okay.
accordance with the statutory
So,
scheme.
so you're saying that to hold the same unto the assignee absolutely is only indicating that the duchy retains no interest.
Exactly. And if you read those two clauses together, no one could possibly say that Mr. Riley could go off and not abide by those terms, which we would say are terms which are imposed as a matter of restriction on him before any actual benefit is received in his hands. It couldn't possibly be said that he would be free to.
But it's not a quis clause, because quis clause is normally that in default of satisfaction of the purpose, the money's
result. It's transferred to him for a specific purpose.
Well, it's an express trust.
Express trust.
If it's a trust at all, it's an express trust.
Yes, but whether it's a trust or whether you analyse it as a contractual measure, you still come back to the fundamental point, which is, objectively, can the parties have really intended that the assignment deed, the release, was covering these types of claims? In our respectful submission, all the indicators are no one thought that RHL had a claim which had any value which was capable of being assigned to the Rileys. No one addressed their mind to the fact that the Rileys might take an assignment of it. Ergo, this claim was objectively viewed by the parties and the parties to the settlement deed as not covered by the release. I mean, it'd be very odd indeed if the parties intended, as a matter of construction, to compromise a claim held by a third party, which, in fact, they have no power to compromise.
Well, the difficulty I have with that is I understand you can always look at a particular claim and say, well, that wasn't in view, but isn't that rather the wrong way round? What we have to look at is what is it that the parties agreed was being compromised, and the argument which was accepted by the judge is that any claims in relation to the various carefully identified subject matters, which thereafter became claims of Mr. Riley, were settled.
Well, the process of construction is obviously a process which involves looking at the language in context. And if you look at the language in context in our submission, the context very clearly shows that even if you might argue the words themselves could literally encompass such a wide claim, that was not what the parties intended by the use of those words.
Well, what you're saying is that it would have been odd if. Sorry, you say that if the week after the settlement agreement had been entered into, the administrators had actually woken up or taken a different view about the merits of the claim, there would have been nothing in the settlement agreement to stop them pursuing it on behalf of RHL.
Absolutely.
And you say that the thing that, and there was nothing in 7.1 which gave Mr. Riley any power to compromise such a claim at the date of the settlement deed. So when the deed 7.1 says hereby releases, he couldn't have done that because he didn't have the power to do it. But what's said against you is, yes, but the context is that he agreed to release any future claims that he may hereafter have arising out of some things which did identify Riley Holdings. Why couldn't he, I think it's said against you, why couldn't he release for the future any claims that he might hereafter have, i.e. acquire, such that on his very acquisition of the claim it disappeared in a puff of smoke? So
that's the tension between the language approach, obviously,
yep,
and the contextual approach.
Yep.
And in our respect for submission, what the judge did was just to look at the language and say, well,
it's a good starting point.
Language in context. I think I think the authorities suggest you can start at any particular point.
Yes,
so,
of course.
but we don't disagree that arguably the language was wide enough to cover conceptually the point. There are some difficulties with the language, which we'll come on to in due course, because if you were to insert RHL as the claimant into the language of the deed, it doesn't work particularly well, and I'll come back to that in a few moments. But I accept that the language of the deed is widely drafted, so that just looking at the plain words, you can see an argument that the settlement deed releases claims by Mr. and Mrs. Riley in relation to a subject matter category and use of the words in connected or in any connected with, and therefore it's a claim by RHL is therefore connected with RHL, therefore you're caught by the wide terms of the release. But if you look at cases like Arbuthnot, which I'll come back to in due course in the Court of Appeal, which is referred to in Kazmini, the courts don't simply stop at, well, conceptually it's possible that this language captures this type of claim. They ask themselves, what was the target of this particular exercise?
Yeah, well, I think you say two things. One is you never actually look at language in a vacuum. You always look at language in context, even if you start with language.
Yes.
The court sort of never says just look at it as take it off to a laboratory and look at it out of context.
Yes.
I think one of the points you made is that you say if you just put in the RHL claim into the language, actually it doesn't fit very well, because it couldn't be a hereby release, because at best it would be a future release.
And we'll come back to look at the language a bit more carefully, but if you look at the step process involved, it's all about the personal position of the right.
But
So we would actually say it doesn't fit that easily. There is, in fact, a textual indicator to the contrary, if I can put it that way as well. But our primary submission on this is that whether you take the language at the start or look at the context, it doesn't matter. Contextually, there can be no doubt this was not on anyone's radar. It wasn't their target. It wasn't in their contemplation. It wasn't intended that this category of claim would be released. And therefore, the judge was wrong simply to say, well, the language captures it, ergo, therefore, game over.
I think if the contextual approach is going to be investigated, I think we do have to understand the breakdown of creditors.
Sorry, my lord,
We have to understand the breakdown of creditors of the company.
Yes, well, they're publicly available.
Yeah.
And in relation to...
and also, to pick up my last point again, looking at the other side of the balance sheet, anything the administrators may have said about whether there were any more assets to be realised at the time.
There was no indication in any of the reports that there were any assets, any assets such as causes of action against the bank, anything like that. Nothing.
But to make good your point, as my lord said, to make good your points about context, or at least even to inform us about the context that parties might have had in mind, it would be helpful to see both what they thought the liabilities of RHL were and the assets, if any.
Well, my lords, some of that material was before the court below. I'm not sure if it's all got to find its way into the supplemental.
Well, I hope not all of it. I mean, just why not just start with the last periodic report?
Yes, the progress reports. So we can download those and provide those to you over lunch.
Not necessarily all of them either. Just
yes.
Well,
I have checked them, and I can give your lordships the information that from those. Obviously, it's not yet in the supplemental bundle and so on and so forth, but it's publicly available information, and I can give you that information. Yes.
All right. Well, is that the end of the prologue?
Well, it wasn't actually, no. But I think
that's just the prologue for Ground 5.
Ground 5. I think probably I'd be risking the wrath of the court if I suggest there was any more.
But you're going to come back to ground 5.
I'm coming back.
In much more detail.
I am, yes.
Well, like now?
Well, I was.
Before I, for one, forget what we've just been discussing.
Well, I'll take the judicial hint and deal with it in that way. Before I do, I think probably I should briefly deal with just some of the scene setting points in advance of the settlement document itself.
Yeah.
Because I think that will hopefully be of assistance to your lordship both on ground 5 and ground 3. And obviously you've gleaned from the judgment that the key parties so far as the events are concerned, well, obviously Mr. and Mrs. Riley, who were directors of RHL, and Mr. Riley, the shareholder. They obviously incorporated Riley Holdings Limited, which went into administration on the 2nd of April 2012. The administrators were in office until 2015, and the company was dissolved or struck off on the 3rd of June 2015. Obviously, NatWest were lenders, bankers to both RHL and to the Rileys personally. And in particular, the principal focus of the claim relates to facilities so far as RHL is concerned in relation to a site on the bank of the River Trent called River Crescent. And that site involved a development, a substantial development involving in excess of 100 luxury flats on the river. And that obviously involved lending from the bank, which by 2008 was in the region of 32 million. Ultimately, the total facilities reached about 36 million as administration. And as at 2008, there was, of course, the financial crisis, which resulted in a substantial reduction in asset values. There was a revaluation of the assets held, which indicated a shortfall, and there were concerns that the flats, which had by then been completed substantially, though not entirely, were not selling as quickly as anticipated, and there was a discussion in relation to further facilities, but ultimately the company's relationship was transferred into the global restructuring part of the bank known as GRG, and that took place in 2009. So the relationship arrangement was moved internally within the bank to sit within the global restructuring group in 2009. And the Rileys' case, of course, in the claim is that the bank made representations to them between 2009 and 2012 that they intended to restructure the facilities and to support RHL to return it back to the mainstream bank. Those representations are pleaded out, and the judge gives the references for them in the judgment, and they're not on dispute on this appeal. The Rileys' case is that they relied on those representations by doing two things: causing substantial funds to be paid by an associated company called NDA Nottingham Limited, which provided substantial funding for fitting out and completion in relation to River Crescent, and also by not seeking to refinance with other lenders on a long-term basis, which would enable them to let out the flats and see themselves out of the financial crisis. They now contend, as a result of the information they obtained from the promontory report.
The first of those, just to be clear, the first of those is, you say, when you say NDA Nottingham paid money to finance the fit out, I just haven't got the detail in my head at all. But was that was that a loan, a gift, or what?
I think it was a loan, because the ultimately NDA was a creditor of RHL.
And is this? And you say that Mr. and Mrs. Riley say that they relied on the representations. They didn't actually. They caused another company to lend the monies. Why do you say they relied?
Well, they relied on, in the sense that they were directors of all these companies, and also obviously derived personal benefits from the companies themselves. But you're quite right to say the reliance for the purposes of the claim is both the Rileys personally and RHL vis-a-vis RHL's claim.
Well, hang on. NDA Nottingham paid money to finance the fit out. Presumably, it did so for good commercial reasons of NDA Nottingham and on commercial terms, because otherwise the Rileys would have been breaching their duties to cause NDA to do it.
Yes.
So why does NDA Nottingham's
well, I think
commercial decisions to lend money
I
form
think
the basis of reliance?
Well, I think in the sense that, in effect, it forms part of the counterfactual case, which is that this is what happened if these money were provided. If the bank had turned around and said, actually, we're not intending to support you in returning to mainstream, but actually we've been earmarked your relationship as one for exit, then the case is that wouldn't have happened, and third party lender would have been replaced. They would have taken third party lending.
Okay, for present purposes,
It may be you're right, Model, that the NDA part is of less relevance causally than the lending relationship with another lender.
well, I was going to say, didn't refinance with another lender. Is there any evidence another lender would have been prepared to lend? But I mean, these are merits points.
Yeah, these are merits points. Yes.
Okay, so we don't need for present
evidence
purposes.
has been attained, and yes, it was not. They're merits points. They're just the context for that. And in relation to the question of obviously the discovery of the falsity of the representations, that's the trigger point for that was 2018, the promontory report. But in advance of the 2018, so I should be a bit more precise in my language. The promontory report is dated 2016, but wasn't actually leaked or published until 2018. So it was 2018 when the Rileys became aware of it. In advance of that, the Rileys had all sorts of complaints about mistreatment in relation to their relationship with the bank, which formed the backdrop for various complaints they'd made. But at no stage did they advance a claim based on the same allegations they make in these proceedings in relation to the claim that actually you told us you were supporting us with a view to returning us to mainstream, and actually you'd internally designated us as an encore asset, which meant we were going to be earmarked for exit by no later than 2013. And it was that key information which the Rileys became aware of following their perusal of the promontory report, which obviously was a skilled person's report carried out with access to the bank's own documents. In 2012, demands were served for repayment, and of course the company went into administration on the appointment, I believe, of the bank. I'll double check that. And I've recanted the subsequent events. The lead into the settlement deed involved initially some correspondence with Nabarro's, and you'll see reference to the Nabarro correspondence in the judgment, and also formed a heavy part of the bank's case that the context for this settlement deed was the Nabarro correspondence, and in particular 3 letters are referred to and relied on by the bank in this respect. I wasn't intending to take you through them that are referred to in the judgment, but there are 3 points we would seek to draw out or draw your attention to in relation to this correspondence. The first is that they're written on behalf of Rileys and NDA, not on behalf of RHL. Any claim that's alleged within them relates to a personal claim by the Rileys and or NDA, not a claim by RHL. Secondly, they don't anywhere allege a claim in the tort of deceit or fraudulent misrepresentation. And more particularly, thirdly, they don't make a claim based on the fact that they had been designated non-core and the bank had been lying to them about what its true intentions were in relation to them, in relation to support and return to mainstream. There is some time lag, however, between the third letter from Nabarro's, which was dated the 21st November 2013, which formed part of the judge's analysis, and the settlement deed, which of course didn't take place until later in 2014. And for your Lordship's note and reference, Nabarro were not acting at the time of the settlement deed, but the last letter that I've been able to identify where they were continuing to act was in June 2014. And the reference for that is in the supplemental bundle behind tab 24 at page 300.
So that's just too fast for me, I'm afraid.
Apologies.
Are we having a transcript?
I don't think we are, actually. I'll check.
Yes. You need to give those references a bit more slowly then, if you don't mind.
Yes.
Can you actually give us the references to the 3 letters that you...
Yes, I can. So it's 1st of February 2013. It's in the supplemental bundle behind tab 17 at page 256. Hopefully you'll find there a copy of a letter with Nabarro's name at the top, addressed to the Royal Bank of Scotland, GRG. And you'll note the clients that Nabarro are representing right at the outset. And you'll note the various grounds of complaint in relation to mistreatment, which are set out in that letter. And then you note at the conclusion, at page 265, it's complaining about loss suffered by the Rileys and NDA. The second letter, dated the 3rd of May 2013, is behind tab 18, page 266. And you can see that this is dated 3rd of May 2013. Again, same description of the parties. This appears to have been a follow-up letter, the earlier letter having not been responded to. And in this allegation, the concerns are raised in relation to a swap entered into in 2008 in relation to a refinancing exercise before entry into GRG, and points are raised in relation to the swap and potentially whether or not there may be an issue arising in relation to that.
It's clear from these letters that the bank did place the company into administration.
Yes. And you can see that, in effect, what was being contended for was irresponsible, negligent, reckless conduct or mistreatment by the bank, with adverse consequences for the bank putting the company into administration, etc. And amongst other things, the loss of value of NDA is referred to at 3.8. And then again, you see complaint is made about forcing RHL into administration in paragraph 5. And then the conclusion, again, is focused on the personal claims that the Rileys have, which are said not to yet be capable of quantification in 6.2. So no doubt about it that Rileys thought they'd been mistreated, and various allegations as regards irrational decisions, misstatements, malpractice, etc. were being made. But none of them were claims in the tort of deceit or fraudulent misrepresentation. None of them were the non-core designation claims which are now being
What
pursued.
about page 272, 5.5? given the increasing public concern in relation to web registrar clients concerned, this was a thinly disguised ploy by RBS NatWest to take onto its books an incredibly profitable asset at a cut price.
Yes.
What's that an allegation of if it's not an allegation of dishonest abuse of power?
Well, it has the flavour of as the judge identified, deliberate wrongdoing, bad faith. I don't think it's the same as saying you said specific things to us, you lied to us, you were dishonest in the way you dealt with it. It is alleging rapacious conduct by the bank, which is alleged to be wrong.
A couple of paragraphs earlier on, there's an allegation of bad faith.
Yes. So I don't demur from the proposition that the Riley solicitors at that time were making allegations of a serious nature to the bank. But
including misstatements.
Misstatements, yes.
Statements, bad faith, preferring their own interests.
Yes, yep, all of that.
Yeah.
So we don't take issue with the judge's conclusion ultimately that included allegations of deliberate wrongdoing, was I think how he described it in his judgment. But to reiterate my three headline points, written on behalf of Riley's NDA, doesn't allege a tort of deceit or fraudulent misrepresentation, does not make the allegations which are now being made in this case. We'll come back to the significance of that in due course. The next letter, as I said, 3rd of May 2030, we're in 3rd of May, so we've dealt with that one. The third letter, 23rd of November 2013.
21st of November.
21st of November 2013 is behind tab 19 at page 274. And same themes we would respectfully submit, but you can see that this is after the bank has purported to send a response denying everything. The Rileys solicitors continue to make complaints in relation to the bank's conduct, and they refer to various reports, etc., which they had complaints about. They talk about the threatened prosecution of Mr. and Mrs. Riley because of the difficult position they put in relation to NDA. They refer to all of those matters, and then ultimately we see the conclusion, which is we don't think you've concluded a satisfactory investigation to our client's claim. A complaint that GRG was not proactive in its dealings with RHL, put a viable business into administration when it ought not to have done, and it said that as a result, Mr. and Mrs. Riley have a legitimate claim against the bank.
So would RHL.
And so would RHL. And you can see at the bottom that
in fact, in reality, in a sense, the primary victim that is being identified by these letters is RHL itself, the company that was pushed into administration when it shouldn't have been, according to tenant, etc., etc.
I wouldn't demur with a proposition that obviously reflecting merits and reflecting loss principles, that the primary complaint would be by RHL in relation to RHL's losses, and the Rileys would be limited only obviously to their losses, their personal losses, which could not reflect those of RHL. So accept that. You can see at the end of the letter, in the conclusion section, a request for a meeting, perhaps a plea for a meeting, you might say. And a meeting did take place. We've got copy of it in the bundle.
Just before we leave this letter, Mr. Sims, bottom of page 277.
Yes.
1.7. We have to question the motives of MCR in producing such an inaccurate and damaging report, seemingly acting against the best interests of our clients and RHL.
Sorry, Mal, I didn't quite catch the paragraph reference.
1.7.
1.7, yes.
Can't remember who MCR are.
So MCR, so this is a report in effect. You can see reference to it at 1.3. Like an independent business review report's my understanding what it relates to. So in effect, what's being contended here is of a theme for what you see in the Tomlinson report, is that a complaint that in some way the bank has procured a report from a third party which has wrongly triggered the company going into administration, artificial distress, if you like. So the complaints made in relation to the Tomlinson theme, if I can put it that way, where the bank wrongly, in bad faith, caused this company, a good viable business, to be put into administration off the back of reports which were not independent and which were faulty and which resulted in this company being in administration and questioning the motives of the bank in that respect. Was the bank intending to take the company, for example, for itself as part of West Register?
But on the face of it, to answer my lord's question, on the face of it, MCR, who subsequently became Duff and Phelps, are an independent firm of insolvency practitioners stroke accountants.
Exactly.
Who were instructed on behalf of the bank to conduct an independent business review into RHL. You see that?
Yes.
At 1.1 and 1.2.
Yes. So those are difficult allegations to make. That we'll come back to this point, no doubt, in due course in the context of other points my own friend might want to seek to make a limitation. But in relation to the context for the purposes of the run into the settlement deed, I don't demur from the proposition that these allegations were being made. What we can see is the bank didn't view them as having any merit and push back on them. So what really we see here is the Rileys thrashing around, trying to end up in a situation where they can have a meeting with the bank to discuss matters. And their objectives are twofold. One is obviously to see if they can resolve their personal position as against the bank. And the other is to see whether or not they can get the bank to support them buying the assets back out of the administration which is being conducted by Zolfer Cooper. And that's what the Rileys said in their evidence, and what we can see. I was going to take your...
Sorry, just again, MCR were not engaged by your clients or RHL. They were engaged to provide a report to the bank.
Exactly. So the complaint that was being made was that in some way the MCR report was used by the bank to put the company administration in circumstances where it ought not to be.
Okay, but sorry, at the bottom of my Lord's question to you on 1.7, it could well be that MCR were acting perfectly properly in producing a report that suggested various things to the bank, which might not have been, quotes, in the best interests of our clients and RHL. I mean, the two are, it seems, there seems to be a vague suggestion that MCR owed duties to RHL or your clients.
Well, your Lordship has alighted on a typical problem that lots of these complainants had. They weren't happy the way they'd been treated. What was their cause of action?
Anyway, okay.
So, my Lord, I don't demur from all of that.
Anyway, that's a merits argument.
It's a merits argument.
To be had if and when you survive this, or succeed on an appeal, or survive the strikeout.
Yes, thinking positively. Yeah.
But for today's purposes, we don't need to go down that road.
And for today's purposes, really, the headline is, all of that's all very interesting, but the key part of this claim really cannot be made without the knowledge of internal designation of non-core. The Rileys know what they were told by the bank. They know what they were told by the bank as regards how the bank was going to treat them. There's emails to them, and there's internal emails and documents by the bank which show that they had a secret strategy in relation then, which they weren't told about. That is at heart their complaint, and it's the RHL's complaint. And all this stuff to do with all these other things, you may, with a following wind, persuade a trial judge that they're contextually relevant and support that case. But on their own, they're met with all the sorts of points which the bank would make about them and would not survive strikeout. I'm diverting slightly from the course I was intending to try and take your lordships, which was to take your lordship, I think, to what happened between the latest Navarro correspondence and the settlement deed. And as I indicated, that you can see at the end of this letter a plea for a meeting, can't you? The third letter. I don't know if your lordships have spotted that. But a meeting then did take place, and we got the minutes for that behind tab 22. And this is dated the 10th of February 2014, so it's Navarro's minutes of the meeting. And you can see that, in effect, the pitch here is from the bank's point of view. We fully considered the correspondence from Navarro, as you can see this is referred to in the second paragraph. Taken legal advice, we're comfortable with our position, and will defend any claim that Mr. and Mrs. Riley NDA should opt, if they should opt to issue proceedings. There's reference to Navarro taking the minutes, and then we see Neil Gibson on behalf of Navarro NG introduces himself and obviously says the usual things about wanting to try and have some sort of commercial deal. And you can see that there's a reference to the administration and the interests of the creditors in the administration. You can see in the paragraph, in terms of the administration, the suggestion is that the principal creditors are the Rileys, the Cleggs, and a number of other smaller creditors. And there's reference to discussions in administrators about that. And then you can see there's reference to press, political, and legal interest in the client's case. And then he hands over to someone called Peter McCown, who was a consultant who was assisting the Rileys in trying to negotiate something with the bank. And you can see that his engagement is focused on assisting the Rileys in acquiring the assets of RHL out of administration. In particular, the River Crescent project was something that the Rileys hoped to try.
Before you go on further there, can I ask who are the Cleggs?
The Cleggs were the constructors of River Crescent, so the construction company. And you can see there's then reference to various different assets at the bottom of the page, page 291. So there's talk about the shed, the car park, the bakery, development land, etc., and also River Crescent and the Yacht Club over the page. And there's obviously a marketing process which is going on. And you can see at the top of the page the reference to best and final offers in February 14. And Mr. McCown identifies what he considers to be the bank's objectives in relation to the process to obtain the best price of the assets, act in the interest of the customers, Mr. and Mrs. Riley negotiate satisfactory settlement of personal liabilities or litigation. And then we see the bank responds, Mr. Brogan responds, well, we certainly want to maximise the value we extract from the assets. However, we've never got to the point of understanding how Mr. and Mrs. Riley propose to repay their personal liabilities. As I stated, we do not consider the claim has any merit, so we're not looking at this altogether. They're separate issues. And there's then various toing and froing as regards what potential deals might be acceptable. And by reference to the Rileys' financial position, you can see at the top of the page, page 294, there's the reference to part of the deal of the bank not recovering the 2.5 million for the personal liabilities, which is referred to as being partly secured by Rufford Hall and valued that property being valued between 850 and 1.2 million. And then there's further discussion, and then there's reference to a potential settlement deal at the bottom of the page between 850 and 1.2. And you can see that there's discussion about how the proposals might interrelate with the administrator, and over the page at 295, for example, the third up from the bottom, you can see the bank emphasising certain matters were for the administrator, not the bank. And to cut a long story short, there's, as appears to be by the end of the meeting, a discussion on the lines of a figure to be paid in relation to the personal liabilities, and the Rileys seeking to buy assets out of the administration. So fast forward from that, we have what appears to be, so far as I can tell, the final letter from Nabarro on behalf of...
Just before you do leave that, though, I mean, it's clear, isn't it, from reading through that Mr. and Mrs. Riley were saying to the bank, we want to buy all the assets of RHL, and the bank was saying, that's not for us, that's for the administrators to deal with.
Yes, I think the Rileys tried to argue that actually a part of what the bank said was, we'd support you in your efforts to try and buy that from the administrators, and they tried to suggest that was part of the deal, and the bank said, no, that's not what we agreed, etc. So there was a bit of argument after the event in relation to that. But yes, in essence, your Lordship's right, that an objective reading of this document is that the administrator's position was obviously appreciated by everyone and was viewed as being a separate matter.
Yes, but what I'm saying is, I'm not sure which way this cuts at all.
No.
I'm making no observations.
No.
I'll make it very clear, but I'm just identifying that there were 2 points being made repeatedly throughout this document.
We want
one is that the Rileys want to buy RHL's assets, indeed all of them.
Yeah.
And the other is the bank was saying, nothing to do with us, that you have to speak to the administrators about that.
And you owe us 2.5 million, and we don't view your claims as having any merit. And in effect, but those two streams were ongoing. I think Nabarro's belatedly after the event tried to suggest there might have been some sort of binding agreement, but I didn't press that.
But it was clear to everybody that if you were going to deal with assets of RHL, the administrators needed to.
Of course, the bank did that. Yes, and we can see as I said, that the latest sort of bookend, so to speak, in terms of Nabarro's, it isn't in fact the correspondence in 2013, but it's a letter of the 5th of June 2014. So this is, of course, a long time after the Thomson report was published in 2013. And you can see the letter is behind tab 24 in the supplemental bundle at page 306. And my Lords, you can see this letter seeks to try and position Mr. and Mrs. Riley to contend that the bank had agreed a figure of 850 for the Riley's personal liabilities, and the bank obviously pushed back on that. And you can see they refer to various extracts from the meeting as to what was and wasn't agreed. And then you can see the current position is identified at the bottom of the letter. That by this stage there appear to have been direct discussions between the bank and Mr. and Mrs. Riley's advisor, Peter McCown, who's referred to in the meeting, and the bank's making an offer which you then see commercial terms which in effect reflect in the settlement deed of the bank offering to pay for the Rileys to pay a one-off payment of 1.1 million to the bank on or before 30th November 2014, or clients to pay 1.25 million installments over a term of 15 years. We understand that absent Mr. and Mrs. Riley's agreement to one or over those options, the bank has stated will call in its security over Rufford Hall, our client's family home and location of the NDA Foundation, place the property in the open market for sale, and apply the sale proceeds to reduce the level of our client's personal liabilities. And then there's a complaint that this was the bank changing the goalpost from the 10th of February meeting. So that seems to be the last letter.
I mean, that was putting it far too high to say that there was actually an agreement, wasn't it?
They were. I think the borrowers were trying to suggest that there was an agreement reached at the February meeting as regards a figure, and that should be enforced. The bank wasn't agreeing to that, saying no, nothing was final was agreed, and the bank. To say the bank had reneged on an agreement is way over the top, isn't it? Given what you've shown us. I'm not here to argue that they were on a sticky wicket to try and argue that there was a binding agreement, and the borrowers didn't press that point. And ultimately, the Rileys ended up compromising on the terms they did. So, what's significant for present purposes? There's no hint or suggestion in any of this that the Rileys' personal claims are considered to have any significant value. And as I'll come on to when we look at the contextual indication settlement agreement, in reality, what the settlement agreement was about was a restructuring of the Rileys' personal liabilities having regard to their means, with the bank getting improved security vis-à-vis Rufford Hall and an improved position vis-à-vis the tenant at Rufford Hall, which was NDA, on terms which excluded security of tenure under the 1954 Act. So the quid pro quo really, in commercial terms, you can see here a valuable release of claims. That's not the context for the settlement deed, or if you look at the settlement deed on its face, what's really being suggested.
Well, as a general pattern, banks aren't going to release any liability without it being full and final.
I don't demur from the proposition that the settlement deed was a full and final settlement. I don't demur from the proposition that it included a release in relation to claims by the Rileys.
Well, my understanding is that they've agreed to take 1.1 million.
Because that they realised that was all they were going to get.
So what? They've agreed.
Well, I think the context for this is that if you read the judgment, the judge seems to have approached the construction issue on the basis of you got a very valuable discount for your release. That's just, in our respectful submission, not supported by an objective analysis of the pattern of communications in advance of the settlement deed, or an objective consideration of the settlement deed. There is no hint in the correspondence which leads to this, that this is a case like Maranello, where actually a central part of the commercial deal was a settlement of what were considered to be potentially valuable claims.
Well, I mean, you'd say that in the same way as the Rileys had no business dealing with the assets of RHL, which were in the hands of the administrators. Likewise, from the bank's perspective, it had always regarded what was going on at RHL as being in the hands of the administrators and nothing.
Absolutely.
Nothing to do with the bank.
Well, that point exactly. But beyond that, on top of that, everything coming back from the bank was, these personal claims are not worth anything. What we're interested in is a restructure in terms of the finances to improve our security in relation to Rufford Hall and to get an improved package, and we'll agree to a payment plan by you based on your sworn asset position.
Yeah.
So that was the point I was trying to get across. You could be forgiven if you read the judgment in the court below, that in some way that there was this valuable discount consideration given for the release of valuable claims. But you don't. I'm not demurring from the proposition there is a release clause which does purport to release a claim.
Also, maybe I'm misunderstanding something. I thought their personal liability was 2.5 million.
Yes.
And as I understand it, the demand was for 2.6, presumably including interest. Is that right?
Yes. So the liability which they confirmed in the settlement deed, perhaps it's a good time now to actually have the settlement deed in front of us. Yeah. But just so your lordships have the point. The point I was really trying to draw out of that contextual background was, you don't see any hint or suggestion that any of these personal claims were viewed as being valuable rights which were being forgotten. as a matter of contextual analysis background to the settlement deed. If we look at the settlement deed itself, yes, of course, there was a reduction.
Well, the total debt, 1.4.23, was 2.716 million.
But let's ask ourselves, what was the context for why that was agreed? And we can see that not simply from the negotiations, but from the face of the settlement deed itself. So let's turn to the settlement deed. It's in the core bundle behind tab 11 at page 270.
Yeah. And my understanding was, from the meeting notes, the bank was saying, we're quite happy to come after you for 2.5 million and enforce against your home and everything else, and bankrupt you.
The bank had some problems, though. It wasn't completely satisfied with its security in relation to Rufford Hall. Rufford Hall was the principal security they were looking at, and they had concerns about the tenancy position in relation to the NDA, because there was a tenancy. So Rufford Hall is the home of the Rileys. It's also where they base the offices for NDA. And so the bank did have some concerns, both as regards the Rileys' ability to pay, but also their security position.
Who were the shareholders of NDA?
RHL was the shareholder.
What we're looking, I'm sure all of that is fair comment, but at the end of the day, we're looking at a settlement.
So let's look
So
at
you look at the two sides of the coin, and what the Rileys were facing was a total debt of 2.7 million, and the bank saying, we will come after you, take Rufford Hall, and bankrupt you.
yes,
And
potentially.
that was the
context.
That was the downside. That was what they were,
Yes.
as it were, settling.
And
And what they agreed to, as I understand it, was that on an early settlement basis, they would only have to pay 1.1. And am I right thinking it was done by way of instalments?
yes. So over a long period of time, I think
A long period of time.
15 years or thereabouts.
So they would keep their home, wouldn't go bankrupt,
Yes.
and
So
pay much less than half the total sum over an extended period.
and the bank in turn, it was getting three things in particular that you can see from the document. One was an improved security position vis-a-vis Rufford Hall.
Yeah.
Two, the tenancy position, which obviously caused them concern to be remedied.
That's the nature of a contract, a deal, is both sides get something out of it.
Yes, but what my point is that there's no hint or suggestion. Sorry, the third point I was going to make was to do with the fact that the bank also reserved the right to itself to have an increased payment structure based by reference to the means of the Rileys. So there was an ability for them to accelerate, in effect, the payments based on the means position of the Rileys. So in effect, the Rileys were, for a 15-year period, you're going to paying us, I think from memory, it was initial 85 and 100,000 a year for the next 15 years. And the bank was getting that the promise of that income stream and an improved security in order to achieve that, with a sworn affidavit position showing that the Rileys didn't have any personal assets beyond the ones that the bank were looking at, and they had a maximum of income of just short of 100,000 on a net basis to them. So the bank was basically taking them for all their surplus income by putting aside their ordinary living expenses for a 15-year period. Mm. And the point I was seeking to make contextually was that the commercial deal here really, if you want to look at it, stand back and ask what was going on here, was a restructure of the personal liabilities of the Rileys vis-a-vis the bank, with the bank getting an improved security position, with not one hint or suggestion that actually a central purpose or focus here was the bank getting valuable release of claims. I'm not demurring from the proposition. There was a release clause. It must have been viewed as objectively as part of the consideration by the bank, because it's in the contract which was signed.
Well, the Rileys have been making quite serious accusations against them for a sustained period. The bank's not going to do a deal like this and then have Mr. Riley coming after them.
I don't.
Why would they? Why would they say we're not going to sue you?
I don't disagree with that.
But you can sue us.
All I'm suggesting is that you'd be forgiven if you read the judgment that in effect the quid pro quo here was you were getting a 1 million discount for this very valuable release. That doesn't sit, in my respectful submission, with the context of.
Well, forgive me, Mr. Simmons, but the whole context of this, as we see from the Nabarro letters, the Nabarro and the meeting, is Nabarro saying to them, look, bank, we're going to sue you, and even if you win, you're only going to get back 70% of your costs. And we can't see how that could possibly be sensible for the bank to be sued by us. Why don't you do a deal? We will pay you money not to sue you.
You don't disagree with any of that. You just simply say, when you say we and us, you're talking about the Rileys personally.
Exactly.
And NDA.
Well, forgive me, forgive me, but at the moment, you're not just introducing ground 5 here. As I understand it, this is an introduction to the other grounds.
Ground 3 as well, yes. And
although my lord's focused on ground 5,
yes,
as I think we all are.
Yes. But no, you're.
And the sooner we focus on ground 5, from my perspective, the better. But you're raising these points in relation to grounds 1 to 4.
I think your lordship wanted me to raise such contextual points as I consider to be relevant to our submissions on ground 3 as well. Yeah. And we do make the point. We don't disagree with the notion that the bank did obtain a release and the Rileys provided that release. But in the context of asking yourself the question, which is the critical question in relation to the question of construction, objectively, are the Rileys to be taken to, as part of the consideration to be agreeing to a commercial bargain whereby they forego claims unknown to them in fraudulent misrepresentation as at the date of this lease? We would respectfully submit that the context doesn't support that.
That begs all the questions which you're going to raise in argument on grounds 1 to 4.
Yeah, yes, this is relevant contextually to grounds 1 to 4 as well. Yes. My lords, I'm conscious of the time, and I probably need to crack on.
Yes.
But I'd invite your lordships to note that in the definitions section, in particular, we obviously have the deferred settlement sum, which your lordships have got, and the early settlement sum. The facility agreements, of course, are not the RHL facility agreements, but they're the facility agreements, the personal facility agreements. You see the minimum annual payments, and you see the reference to the new legal charge being granted in relation to the property, which is Rufford Hall, reference to the personal guarantee. And you see the sworn statement and the role that plays at 1.4.21 in relation to their asset position, and then the declaration in relation to total debt. We have the settlement terms, which agreeing to the early settlement sum or early settlement payments, and you then have the details as regards additional conditions in clause 3, so the new legal charge, which assists the bank in terms of perfecting its security, and you also have the deed in relation to the tenancy agreements referred to, and that document is at Schedule 2. The relevant page for seeing the security of tenure provisions is at page 288 in the clause 6.11. And then you see the reference to the existing security also being relied on by the bank. We then have events of default in clause 5, and you see at 5.1.4 the role played by the sworn statement, and you see then in clause 6 material change in borrower's asset position, such that the amounts paid can be accelerated if the asset and liability position of the Rileys is improved. You see the asset position of the Rileys is annexed at page 300 within Schedule 4, showing a net liability position, a negative liability position having regard to the bank's position. and a net income of just under £100,000. Turning to the
matrimonial home, that's Rufford Hall, is it?
Rufford Hall, yes. And then we have the covenant not to sue, and the release is in clause 7, which obviously lies at the heart of this case. And we see the earlier definition, of course, of the Rileys as the borrowers. And we see the reference within clause 7.1 to hereby, the borrowers hereby releases and forever discharges. And I think Lord Justice Snowden has already raised the point about that not sitting easily with an RHL claim. We would say the reference to it may have or hereafter can, shall or may have, but similarly doesn't sit with claims vested in third parties. And then we have the facility agreements. Of course, that's the personal facility agreements, not the RHL agreements. The personal guarantee, the legal charge over Rufford Hall, and the reference obviously there to NDA, or Riley Holdings being a catch-all provision. Of course, if this was contemplating a potential claim assigned from RHL, you wouldn't have Riley Holdings drafted in that way. You would have reference to presumably the facility agreements of Riley Holdings Limited. And so if you put RHL, frankly, the reading becomes discordant because you have RHL releases and forever discharges claims it may have arising out of in connection with RHL.
That's not what anyone is contending for here.
No.
That's not the construction argument.
No, it's not. The construction argument is that to place emphasis on the words arising out of or in connection with, and to say that those are wide words which bear a wide meaning. In that context, I should probably now go to one of the authorities which...
Well, sorry, the words are that it,
yeah.
Well, being the borrower.
Yeah.
I think we must take it to mean they.
Yeah.
Because they are human. Arising out of, that they may hereafter have against the bank.
Yes.
Arising in connection with Riley Holdings.
Yes.
I mean, if I was to extract the bits of this word that's relied on against you, it's saying the current claims that are sought to be brought in the capacity of assignee are claims which they hereafter have against the bank in connection with RHL.
Yes, so that's in effect the reasoning of the judge at first instance, the point made against us.
So I understand you accept that is a
capable.
That's capable of bearing that meaning on its face.
Yes, we do accept it's capable. It sits oddly, but it's capable.
Although you do say that those words in isolation are capable of applying, but the words hereby releases and forever discharges are not, because it was not within their power at the time to do that which...
Absolutely.
So that you said the object, the subject of this clause, could linguistically fit, but the actual doing of the clause, what the clause purports to do, is not something that could be done. So you've got to read it together.
Yes, my lord.
What about clause 7.2 we haven't looked at yet?
Well, I'll come back to clause 7.2 in a moment, but can I just take you briefly to an authority which I think...
Why don't we look at this document as we're here before we look at the bundles of authorities?
Oh, okay.
Please explain to me
yes.
why clause 7.2 is not damaging to your argument.
Well, the way we would put it is that you already have the words arising out of or in connection with in clause 7.1, don't you? And so I think my learned friend is saying that in some way clause 7.2 is even wider because you've got arising out of or in any way connected with the release claims, which already has arising out of connected with. Therefore, it's very, very wide indeed. And our short point in response to that is that you can clearly see the target here is to obliterate personal claims by the Rileys. And the person who is drafting this clause is releasing those and then is ensuring that's well and truly obliterated in relation to the covenant not to sue. But you can't simply extrapolate that out to say that it actually contemplated a claim by a third party, RHL, simply by the use of those wide words. That wasn't what the parties were intending. And we would say that whenever that you see wide words used like arising out of and connection with, even if it's a double layer approach, that still takes its context for the task at hand. And it can't be used literally to have a ridiculously wide ambit. That's not what the task at hand was. The task.
Well, why is it? I'm sorry. Why is it a ridiculously wide ambit? Why is a claim by Mr. Riley as assignee of RHL via the Duchy of Lancaster for misdeeds by the bank? Why is that not in any way connected with the released claims?
My lord, I accept as a matter of language it's potentially capable of falling within those words, but we see in the authorities, which I was briefly going to come to, that the authorities' approach in relation to these words arising out of any way connected with is to focus the court's attention on the task at hand and to read that by reference to the task at hand. And if the court can see that the task at hand, which the draftsman is seeking to obliterate, is the personal claims by the Rileys, which they've been intimating in correspondence, which the bank may think are nonsense, but they want to get rid of. They don't want to have Mr. Riley pursuing those personal claims or Mrs. Riley pursuing those personal claims. That, in my respect, submission was the target of this settlement deed and this release clause, not the very separate conceptual issue of an assigned claim, which commercially could have been assigned to anyone, as my Lord Justice Phillips observed. Commercially, the bank knew it was exposed to an RHL claim as at this date by anyone. It was in the hands of the administrators. The bank could have tried to buy it. A third party could have tried to buy it. Anyone could have tried to buy it. It was not an asset which was in contemplation of the parties as subject to this deed.
I mean, if I understand it also, I mean, what you say is that if clause 7.1 is confined to personal claims, as defined the released claims, the claim by RHL, which, as you've already pointed out, wouldn't overlap with the personal claims because of the reflective loss principles.
Yes.
Couldn't be said to be connected with the personal claims because it's just a legally separate claim. I mean, it might relate to the same facts in the broadest sense, but the claim is not connected, or the proceedings wouldn't be connected. I mean, in any, as I understand it, say in any legal way.
Objectively, yes. Connected there must have its limits. And I am anxious to take your lordships to a case on this because I think it's
all right, go on.
It's a useful, please if I may.
Yes.
Pretty please. Behind tab 5 at page 55 for the authorities bundle, so it's the first authorities bundle. This is a case which is...
Sorry, which tab?
Behind tab 5, please, within the first file.
Oh, button.
And you're using the continuous pagination, it should be page 55. And I think the bottom right corner. And this is a case which was actually referred to in Kazmini subsequently. But I think it's worth going to it. You can see that it's a decision of the Court of Appeal of...
I'm afraid my bundle is not
you having problems.
operating.
Do you want us to see whether we've got a solution to it?
I think I fixed it.
There's still a valuable invention to be made there for ring binders.
Yes.
So
I think the moral of the story is actually just don't put so many pages into the bundle beyond either that or buy stronger bundles.
Yes, and double-sided, etc. But yeah.
Don't include the Three Rivers case.
Only include the relevant extracts.
Yes.
Your investors in your invention may have to be warned of these easier solutions. But anyway.
So, my lords, Arbuthnot and Fagan, you can see that this is in the context of Lloyd's insurance market and a dispute between Lloyd's names and the underwriting agents as regards the construction of a pay now, sue later clause. In effect, the debate was to do with the ambit of the restriction on Lloyd's being able to bring claims against the underwriting agents in relation to that clause. And you can see it's an appeal from a decision of Mr. Justice Savile on the construction of the clauses in the standard agency agreements, and the issue was conclusion of bringing claims for negligent underwriting before paying the sums demanded. And you can see that the judge held that the clauses precluded the names from making any legal challenge to the assessment of liabilities, expenses and outgoings of the underwriting business until they paid the cash. But their claims arising from negligent underwriting were not or need not be related to cash calls made against them, and so therefore they could proceed. The underwriting agents appealed, and the appeal was dismissed. The court interpreted and focused on the payment, the purpose of the pay now, sue later clause. And then you see the observation of the master rolls about the construction process, which one might suggest is Wood and Capita many years ago. But you see the same similar principles in relation to the construction of words in their context. If we turn to the judgment of the master rolls first, that's at page 57 of the continuous pagination, and you see the clause in question which is being construed. It's at page 58, clause 9, headed undertaking by the main to pay all liabilities and outgoings, and then there are 3 sub-clauses which are being considered. It's in particular C, which was the key part of that clause.
This clause is often referred to as pay as paid, isn't it?
Pay now, sue later.
Or pay as paid.
Pay as paid. Yes. I think it was in the context, I think, of the market operating so that the names would pay up, and then if they had any beef with the agents, they would deal with that after. That's the sort of commercial heart behind it all. But the particular clause in question which we're looking at, you can see it's in C, had the words arising out of or in any way connected with. So you can see that was the focus of the submission as regards the potential reach for the condition precedent to the issue of proceedings. And you can see that's then analysed and interpreted by reference to the issue at hand by master rolls. And at the bottom of page 59, you can see that the submissions being made on behalf of the underwriters, and you can see then submissions by the names that as regards what the purpose of this was, namely to preclude the name from making any legal challenge to the making of a requirement or to its substance until he's paid the sum called for. We can see the names construction was preferred, and one of the arguments which was being made was that that was wrong. We can see the analysis in the Court of Appeal as to what the draftsman was seeking to do and the task at hand, if you like, at the bottom of page 60 in the conclusion in that respect as regards the cutting off of escape routes by the draftsman, which is, I think, how it's been described by master rolls, and clause 9c being the way of doing that. And then you can see the submission over the page that the names construction failed to give effect to the full terms of the subclause, parcel, which would on that basis be superfluous. He may have been right, but I do not find the point persuasive, even if correct. In drafting a clause of this kind, a draftsman's primary concern is not to avoid repetition, but at all costs to avoid leaving loopholes which an unscrupulous party might exploit, even if this does lead to repetition. And then we have Lord Justice Dean's observations and judgment at page 62. And in effect, he concurs with the judgments of the Master Rolls and Lord Justice Hoffman. And then skipping on to Lord Justice Hoffman's judgment at page 66, you can see the first part of it is sidelined.
I mean, just pausing for a second before you get to Lord Justice Steyn, the last paragraph of Lord Bingham's judgment is the one that is usually cited in many subsequent works.
Yes. And I think is reflected in the headnote passage, which I referred to.
Yes.
I would support it and endorse it, and encourage your lordships to have regard to it, of course. Sorry, I was skipping over quite quickly, conscious of the time, but I've given you, I think, the reference to Lord Justice Dean's concurring judgment, brief concurring judgment. Agreeing with the judgments of the Master Rolls and Lord Justice Hoffman. And you can see what's described as the semantic analysis of Mr. Eder being rejected by him as well, again by reference to the purpose of the clause. And then Lord Justice Hoffman at page 66, we see an illuminating discussion about the use of the words, the expression connected with, which I recommend to your lordships. And that passage runs over from page 66, over the page to page 67. And the Shakespearean reference to taking words literally, the extent to which you can find connections between Macedon and Monmouth. And then we see back again to the need to focus on the relevant purpose in hand. And you also see the rejection of the notion that there may have been some unnecessarily further overlapping or laying or insulating as not being a compelling reason to adopt a wider construction in his final paragraph at page 68. My lords, that is picked up on in Kazmini in tab 16 by Lord Justice Moore-Bick in an appeal concerning a decision of Mr. Justice Flow at first instance in the commercial court. So I think that Kazmini probably falls into the second file. So the facts of Kazmini were that Mr. Kazmini and associated companies sued Mr. Siddiqui and associated companies, and Mr. Kazmini and Mr. Grano provided finance to Mr. Siddiqui to enable the commercial exploitation of certain technologies. Mr. Grano was not a party to the claim, although he had himself intimated claims against Mr. Siddiqui at the time. And you can see that on the first day of trial, Mr. Kazmini's claim against Mr. Siddiqui settled. And the settlement deed is referred to in paragraph 3 of the judgment of Lord Justice Moore-Bick. And you can see drafted in wide terms in clause 5, which is sideline reference for your lordships. It's the opening words in the preamble within clause 5, which is the key operative part of the release. All and any claims, etc.
Including future claims.
Including future claims. And you can see it has the words in any way connected with as well. And after the settlement agreement, Mr. Grano then assigned to Mr. Siddiqui his claim. See that from paragraph 4.
Assigned to Mr. Kazmini.
Yes.
Claims against Mr. Siddiqui.
Yes. Did I say it the wrong way around?
I thought you said you assigned to Mr. Siddiqui. Maybe I missed it.
It may be my error, but you're right to confirm how it was, yes. So, in effect, the person who settled the deed, settled their claim, was then pursuing a claim assigned by them to by a third party after the event. And there was an application to strike out or for summary judgment on the basis of compromise. And you can see that at first instance in paragraph 5, Mr. Justice Flo dismissed that on the grounds that the agreement did not extend to any rights of third parties that Mr. Kazmini might subsequently acquire by assignment or otherwise. And you see that the Court of Appeal look at the submissions, which is for Kazmini, however broad the language, you have to look at the context for the object and scope of the agreement in paragraph 7. And then we see in paragraph 8, the agreement is drawn in very wide terms, and I'm left in no doubt that the parties intended it to encompass all rights and obligations between them arising out of their dealings in relation to technology in question, etc. And then there's reference to BCCI and Ali in the next paragraph as regards the problem of deciding what parties intended by the scope of broad language and by reference to BCCI Ali in the House of Lords, an investors' compensation scheme, and then there's the reference you see within paragraph 9 to Arbuthnot and Fagan, and the passage I've just taken your lordships to. And according to the judgment of Lord Justice Moore-Bick, this is another way of saying the same thing as Lord Nichols said in paragraph 29 in BCCI and Ali. And then we see the treatment of the submissions made by Mr. Miles. And then there's the reasoning. And the key parts of the reasoning are paragraphs 11 through to 15. And I might invite your lordships just to briefly read those paragraphs to yourself. But in our respectful submission, the objective factors which were persuasive to the first instance judge and also upheld by the Court of Appeal are as equally persuasive in this case as it was in that case.
is an obvious distinction between the two cases. You may say it's of no value, but Mr. Casimini was not a 100% shareholder in Mr. Grano.
You could make that point. In my respectful submission, actually the contextual factors in this case are stronger. I'm not suggesting they're precisely on all fours, but actually they're stronger because in that case, Mr. Grano was making a claim.
You might also say that the 100% shareholders have been displaced by the appointment of the administrators who were in control of.
Exactly.
100% shareholders have really no say in what happens to the assets of the
This case
company and administration.
This case is stronger, in fact, than that case. It's even more stark in this case.
Because the bank had expressly said in the course of any dealings, if it's anything to do with RHL, you've got to talk to the administrators, not us.
Absolutely. So in effect, if you look at the objective factors in this case, and you measure them up against the objective factors considered in that, we would say both parties were aware RHL, the third party, was in a position to make a claim. The beneficiary of the release had not sought to bring them into settlement discussions. No express proviso was made for the possibility the third party may assign. Of course, that's hardly surprising because there's no indication anyone addressed their mind to it or thought that it was in contemplation. No one viewed the Rileys or the company as having a claim of any substantial value. You would have expected a business like draft from the bank to have addressed the issue if in fact it had been in contemplation and provided for in terms. The fact that it wasn't strongly suggests the parties didn't envisage it and didn't direct their minds to the claims arising between them as original parties. Sorry, they were only directing their minds to claims arising between them as original parties. And there's no suggestion the amount paid under the settlement reflected to any extent the value of third parties' claims, which in any event weren't in the power of the Rileys to give. And the overall consequences is the beneficiary of the release would get a windfall. In our respectful submission, those factors are of themselves overwhelmingly in favour of a conclusion that whatever semantic points there might be as regards use of language such as in any way connected with, objectively, that wasn't what the parties were addressing between themselves as at the time.
Well, there are quite a lot of distinctions, aren't there? In that Mr. As I understand it, Mr. Grano was a separate investment.
He also made loans and investments, yes.
Yes, so these are two different streams of claim, aren't they? That Mr. Casimini had one investment he was claiming on, and there was another by Mr. Grano. Whereas in the current case, the claims of the Rileys and of RHL would be in relation to exactly the same matters, wouldn't
they? Well, they conceptually
might be different loss.
The subject, there was a connection with the subject matter because of RHL. There's no question of that. But the reasoning and analysis of the Court of Appeal in the case was not, you can't get yourself within the words connected with. So you see that from paragraph 13. The broad language potentially allowed for the argument to be run, but yeah. Just the court concluded that the context limited it. But
the thing is that Mr. Grano's asset, as it were, which he sold to Mr. Casimini, was an entirely independent asset that Mr. Casimini was entitled to purchase, and and as the court said in that case, there's no reason to assume that that was encompassed within the settlement of Mr. Kazmini's.
But so here, the company was a separate legal personality who was under the control of the administrators at the time.
Yes, I can see that, but the claim would be for the same matters, but the administrators had a claim in relation to which its creditors were primarily the bank and the Rileys, and it seems to me that it's not hard to construe this. Well, this would be the argument in connection with Riley Holdings as encompassing potential claims of Riley Holdings, which are subsequently transferred to Mr. Riley to bring in his own name, rather than because at the end of the day, what this is attempting to do is to say, you owe us 2.7 million. We will take less than that, as long as it's paid. What it's trying to stop happening is Mr. Riley not paying even those lesser sums because he's got some other claim against the bank. They don't want him turning round in X years' time during the 15-year period saying, hang on a minute, out of this very connection, I've got a claim against you which I can effectively set off.
But I think all that ignores is that, assuming for present purposes this is a commercially valuable asset, it lay in the hands of a third party who could assign it to anyone. So far as the bank was concerned, even now we could assign it to another. We could assign it to another company, for example, and it wouldn't be in the Riley's name. I'm not suggesting we would, because the terms of the assignment obviously were to us from the. But thinking about it commercially, looking at it as between the bank and the Rileys at the time, it wasn't the Riley's asset. In the same way, the Grano claim wasn't the asset of Mr. Kazmini.
No, but the Grano asset was plainly a valuable asset, which an independent asset, which could be separately dealt with. The thing about the Riley Holdings asset, OHL asset, is that the only people who could really bring that claim would be the Rileys.
No, not at all. Absolutely not.
How would any third party be able to bring the claim?
Well, the third party could bring that claim as an assignee. There are plenty of entities.
On the basis of whose evidence?
Well, objectively, that happens all the time. You can take judicial notice of the fact that it happens all the time in commercial cases, insolvency cases, that valuable consideration is provided to the administrator by all sorts of different people for taking these assignments. In fact, the administrators can be criticised if they don't to follow a process for obtaining best value.
I understand that there may be many claims which administrators can demonstrate and can be sold, but a claim by Riley Holdings against the bank in these circumstances would be very difficult for anyone, including the administrators, to make good without Mr. Riley.
Not at all. The administrators could go to the Rileys and say, well, you've got a duty to hand up the documents to me. You've got your office holders. I've got powers under the Insolvency Act to get the information from you. I can see from the documents, this is what you say you were told. I can see from the disclosure, which we've now got from the bank following issuing of proceedings. Obviously, we're mixing the time periods here, but that these are valuable claims, because actually what the bank told you was untrue, and the company has a claim against the bank, and the administrators bring those proceedings. They have a duty to cooperate with the administrator in order to enable those proceedings to be prosecuted. In my respectful submission, the reason why we see no hint of this contemporaneously is because no one addressed their mind to this at the time as being a possibility. They didn't. There's no hint in any of the contemporaneous correspondence. The bank has given no disclosure to suggest that anyone contemplated that this was directed at the risk of a signed claim.
Well, I mean, I understand that. I mean, just I think you also say that at any point at which any question of an asset of RHL was raised in the negotiations of which the claim would be won, the response of the bank was, we can't talk to you about that, that's all in the hands of the administrator.
Exactly.
Yeah, just so I've understood the facts of Tasmini, I mean, as I understood it, there were said to be close connections between the proceedings.
Yes.
Or at least in some part. I'm trying to understand what paragraph 10, Mr. Miles, who was in fact for Mr. Siddiqui, the defendant, is that right? I think was saying.
Yes. So there were in effect two points were being sought to be made in relation to the connection. One depended on the words right at the end of the clause, or by any person whosoever. Do you see that right at the end? At the end of the preamble clause in clause 5.
Yeah.
And that was rejected. And then the secondary argument was using the words in any way connected with.
And the Court of Appeal appears to accept the argument that the claims now sought to be made by assignment or following the assignment were in fact closely connected with the previous proceedings. So in other words,
yes.
Mr. Grano's claims were in fact, they talk about, I think it's the tripartite agreement under which investments were made both by Mr. Grano and by Mr.
Yes, I mean you can see the close connection in paragraph 2 as well, I think.
Yeah, I'm just trying to. There were loans which were separate, but there were actual claims under the same agreement.
Tripartite agreements. Yes, you're right.
There are two different things, but the Court of Appeal seemed to accept that as a matter of language, it can certainly be said the claims are closely connected to the previous proceedings and the dealings between the parties. However, and then they go on to make the points they make in paragraph.
Yes, it's paragraph 13 really. For the purposes of Mr. Miles' argument, the critical phrase in clause 5 is in any way connected with, since that enables him to argue with some force that the claims of which Mr. Kazmini is now seeking to make are sufficiently closely connected with the previous proceedings. So they don't say we reject as a matter of language.
The context is the...
Exactly.
Yes.
My Lord has the point.
Yeah. But you say, when you say the context, you say it is possible. The context you say is that the claims by RHL at the time of the settlement agreement were in the hands of the administrators, could have been perfectly well brought by the administrators if anybody had thought they had anything in them.
Exactly. No one thought they had anything in them, because you can see that they were treated as having no value, and the administrator ultimately, obviously a few years later, went into the dissolution process, which you only go into under paragraph 84, I think, of Schedule B1 if there are no assets. So this was never viewed as a valuable asset at the time.
But the claim, had it been addressed at the time, I mean, you say that the administrators could have sold the RHL claim against the bank to somebody, not necessarily Mr.
Yeah.
And then the claim would have been what? That the bank, by its conduct, let's leave fraud to one side for a moment, but the bank, by its conduct in breach of all sorts of duties, by its misrepresentations and so on, destroyed the value of the company.
Well, yes, if you're viewing the claims without the knowledge of the fraud, if I can put it that way. But obviously, as at that time, the non-core claims were not known by the Rileys, and it doesn't appear any evidence that anyone addressed their minds to that claim. But you're right, the sort of difficult claim of there's been this treatment in some way, the bank is in breach of its duties, there's been artificial distress which has damaged this company's business, etc., would be the way it would have been run. And that could have been run by reference to the documents, actually.
But the way it often happens is administrators conduct Section 236 examinations, they call for documents, they assemble evidence to decide whether there's a good claim or not. That evidence is admissible in subsequent proceedings by
Exactly.
reason of the statute. And then they decide whether they want to pursue it with litigation funding or not. If not, they offer it to somebody who may be prepared to take it on, together with the evidence they've accumulated,
And
and get it the best price now for creditors and leave the claim to be pursued in the future with the benefit of the evidence that they've accumulated.
it's a bidding process.
Yeah.
There's no indicators at all in this case that concern that actually the Rileys might take a cause of assignment in some shape or form was remotely in anyone's contemplation at the time. It just didn't feature.
Well, it would be very difficult for the Rileys to take an assignment on normal terms because they had no money.
Exactly. Perhaps another contextual.
But what we're dealing with here, though, is the rather extraordinary position where Mr. Riley has, years later, taken an assignment on terms which, on the face of it, are not primarily for his benefit.
Well, he will have some benefits out of it. He's a creditor with Mrs. Riley for. Obviously, we can give you the figures over the short lunch and adjournment, but it's not an insubstantial sum of money. I think from
And that will then be used to say, well, actually, we no longer have to pay you the instalments which are due under the settlement agreement.
Well, that is the dispute.
Because we have a set of arising out of claims in relation to Riley Holdings.
That is the dispute we now have because of the subsequent discovery of the fraud.
Well, what will actually happen is if he recovers sums of money, he will say that the payment of those monies will pro tanto discharge
Exactly, that too.
his liabilities, or in some way,
Clearly,
so that the bank doesn't double recover.
yes, unashamedly, that is the consequence. So the bank might like to think that the clause was to cover that mischief after the event. That's not what the clause was aimed at the time. It might like to think that afterwards.
Well, the clause is aimed if Mr. Riley hereafter obtains a claim against the bank in relation to Riley Holdings, he settled it. So that he cannot do exactly what you are now saying that he will do.
Well, no, because it's RHL's claim
Which he's now acquired.
on the terms he has, yes. But that falls outside the terms of the release. So therefore, conceptually, it is outside the scope of the release.
But the settlement, so the settlement that you, on that footing, the settlement that would be affected by the deed would not be a settlement as at the date of the deed, but it would be a settlement that would only take effect at some later stage when the assignment took place. And you say that's the timing inconsistency of the earlier words, which I think you see an echo of in this, Casamini, don't you?
You do, yeah.
Because they were also recognising that the settlement, if there was a settlement, would have to have operated at some later stage, rather than at the time at which the agreement purported it to operate. I thought I'd just read it. I read that somewhere.
Is that regarded as an obstacle?
Well, I think that the way the submission was put was the same, wasn't it? Which is, once it's come into Ms. Casamini's hands, they're discharged. You see that, for example, the argument is at the end of paragraph 8, which of course must have been rejected by the court.
Was it any part of the court's reasoning that there was a problem over settling a future acquired claim by way of assignment?
Well, I think it's certainly inherent in the reasoning, isn't it? Because they're saying that the objective purpose of this was to settle the claims as between the parties, not by reference to a claim which...
Where are you looking at now?
Well, I'm looking at the submission at the end of paragraph 8, which is the sort of point about the claim coming into the hands of Mr. Kazmini and being discharged.
They say what the result that once they came into Mr. Kazmini's hands, they were discharged.
Yes.
But as I read it, and I've only read it through quite quickly, my understanding is that they say, well, that wasn't in contemplation, and that's not the right construction. But I don't see that they're suggesting that there would be any problem with a settlement or a discharge of claims which were acquired in the future from a third party.
Well, I think it's inconsistent with the conclusion, isn't it? Because on that basis, you would say that in relation to Mr. Kazmini, that actually when the asset came into his hands, it fell within the settlement deed. So I think it's.
But I think my lord's point to you is well made, isn't it? That they aren't making the point that, other than as a matter of interpretation, there's something technically impermissible about agreeing to do
not
that. I think
I accept that. I accept that. There's nothing technically impermissible of a bargain of that nature.
If that's what the
If
parties
that's what the parties intended.
But it didn't. What this agreement doesn't have, so far as we can see it, is, at least as far as I can see, in clause 5, it doesn't have the same wording that we have in clause 7 of hereby releasing.
No, it doesn't.
It's not a hereby release clause. That's a question of simply of interpretation as to whether.
Yes, that's a further point of distinction. It does, of course, have whether past, present, or future.
And in other words, yes, you're saying that both it has.
Yes.
Okay. All right.
Yes, both points, I think.
No, but I think to answer my lord's point, there's nothing technically impermissible about an agreement which, if properly construed, would operate both to release claims now possessed by the party and claims which he may subsequently acquire. You can do it.
You can do it.
But what you say you can't do is purport now to release something over which you have no control. And if that's what the agreement purports to do, it's an indication that's not something it's intended to do.
And generally speaking, in my respectful submission, ordinarily, parties in full and final settlements are settling the claims which are in contemplation as at that time, not future, not in relation to causes of action which may relate to future events.
Well, the reason that people put the future wording into most clauses is either because, as I understand it, post-Ali, it's possible the law discovers a cause of action that nobody thought of at the time of the settlement agreement, and they want to provide for against that possibility of a newly discovered cause of action arising within a limitation period, and they want that barred. Or because in, for example, personal injury claims, somebody may have suffered an act which, unbeknownst to anybody, may cause illness like an asbestos-related illness or something in the future, where the damage, cause of action only arises in the future, but in relation to an act which has already taken place, and the reason for including a futurity clause, if I can put it that way, is to close off that possibility as well.
Exactly. Just there was a brief passage in the Vice Chancellor's judgment in BCCI and Ali in the Court of Appeal, which touches on this point. Perhaps over the short lunch, you just can look at it in paragraph 7, or we can look at it now. But briefly, the point is made that normally settlements are concerned with claims arising out of facts which have occurred as at the date of the agreement, not events occurring after. The volume it's in is, if you want, it's in volume 1, behind tab 7 at page 55. Obviously, in BCCI and Ali, the clause was different, but nevertheless was wide-ranging. If you want to remind yourself of the release clause in BCCI and Ali, you can see in the Vice Chancellor's judgment it's set out in paragraph 1.
So which paragraph is the one?
So the release is in paragraph 1, but the paragraph which talks about this timing point is in paragraph 7, where the Vice Chancellor is dealing with a construction point, and it's the last two sentences really that we're focusing on for the purposes. A further example relates to claims against BCCI arising out of facts occurring after the COT3 agreements were signed. No one suggested the claims of that sort would be barred by the breadth of language of the COT3 release, though clearly they were accepted as not being within the clause.
Really sorry, I'm not sure I've followed the reference or what you're saying about this. We're looking at tab 7.
Yeah, so if we look at the release in BCCI and Ali, that obviously...
So what are we looking at, paragraph 55?
Sorry, page 55. Oh, have I got the wrong reference?
No, sorry.
Internal 55, is it?
Yes.
Oh, right.
Page 89.
Apologies.
Yes.
So the clause itself is internal page 53 or continuous pagination 87, and then paragraph 7, which I was inviting you to look at, which is the paragraph where the Vice Chancellor deals with points which literally might be said to be caught by the release, but actually everyone recognised was not caught by it. And there's a sort of list of various different factors. There's a discussion about employees in their capacity as depositors as opposed to employees, etc.
The point I was putting to you for comment was the obverse of this, which is that often somebody, a defendant, potential defendant, will include language applying to claims that may hereinafter be asserted in order to cover off the possibility of being sued on a newly discovered cause of action or for damage arising after the event in relation to prior actions. And
so that's what the language, the wide language, is catering for, not for the scenario of a new claim arising out of new facts after the event. It's very rare to find a party willing to agree that type of bargain. And the claim here is slightly complicated. It's an existing claim in RHL's hands, but it's a new claim vis-a-vis the Rileys, because obviously it's not in their hands. So there would have to be some sort of event, valuable consideration, payment deed, whatever, entered into afterwards. That's the point I seek to make. I'm not sure if I've articulated it particularly clearly, but it's an additional point we would respectfully submit, which supports the notion that objectively, if parties contemplate that the ambit of their settlement, it doesn't just simply relate to their past acts, but also future events. In my respectful submission, the court generally work on the presumption that you would have to specifically address that.
Now, have you covered ground 5?
I have.
Good. So that's an obvious point at which to break off, and you can deal with grounds 1 to 4, 2 o'clock.